But today we have Professor William Baude from the University of Chicago Law School. He's a professor of law there as of this year, so congratulations on his new appointment. His history is an undergraduate at the University of Chicago in mathematics and economics, and then he went to Yale Law School, and after that clerked with our friend Michael McConnell, and then with John Roberts, Chief Justice. He then went into the practice of law, went to Stanford Law School, and then University of Chicago Law School, where he is now. He has a number of publications. Let's begin with the one that he's telling us about today on constitutional liquidation. He has another one, Arguing with Friends, The Court or the Constitution. These are all in law reviews. Qualified Immunity Unlawful, Originalism as a Constraint on Justice. He was telling me about his meeting with Justice Scalia and how that influenced his way of thinking and his education. His talk today is on Madison's constitutional liquidation. And this word liquidation doesn't have the meaning that Lenin gave to it.
I'm always afraid of that.
Of eliminating your enemies. But something altogether different. It was first used by Madison in the Federalist, in Federalist 37, perhaps a crucial paper in the Federalist, beginning the second half of it. And that particular paper, 37, I think is the most interesting theoretically in the whole Federalist. So this is William Baude.
Thank you. Thank you. So this paper, Constitutional Liquidation, is about a recurring problem in constitutional law, which is when and for what purposes do we look at post-ratification practice under the Constitution. So lawyers and scholars all basically understand the idea of judicial precedent, cases decided by the courts that establish some sort of principle. But a lot of constitutional law happens and has happened outside the courts, in the Congress, in the presidency, and so on, in the states, among the people. And there's a big question about whether that kind of practice ever counts for anything, and if so, how do we take account of it? What does it mean? So just sort of two historical examples to kind of bookend this. One of the most notable examples, sort of from the early 50 years of the country, was the debate about the constitutionality of the National Bank, one of the greatest constitutional controversies of the founding generation. When the bank was proposed, Representative James Madison opposed it in Congress. He was the first person to argue that the bank was unconstitutional, and he delivered an amazing speech about the limits of federal power, the dangers of finding implied powers in the Constitution, and all the reasons that the national bank might destroy the structure of American government if it were allowed. But Madison loses. The bank gets passed over his objection in Congress, and then it goes to George Washington, who asks his cabinet for opinions about its constitutionality. And Thomas Jefferson and Attorney General Randolph take Madison's side and say, this is unconstitutional for all the reasons Madison gave and more. You need to veto it, Mr. President. And Alexander Hamilton comes to the rescue and urges the president to sign it. And so Madison loses again, and the bank is passed and signed over his objection. This bank is chartered. It's regulated in various ways by Congress for 20 years, becomes a fixture of our early economy. Eventually, its charter lapses as politics change a little bit. Then it comes back. So 25 years later, James Madison returns to the bank debate. This time he's president. And there's a debate about whether to pass a second charter of the bank, whether to keep this bank project going. And the bank's opponents think, finally, we've won. We have Mr. Opposition in power, wielding the veto pen, ready to stop this monstrosity from happening again. And after a little bit of back and forth, Madison betrays betrays what his allies had thought they were going to get from him, and says, actually, I'll sign it. He says, the constitutionality of the bank has been liquidated by practice, has been settled by the practice that's happened, and so my own individual beliefs, my own objections to its constitutionality are now overruled and settled by the people. He's accused of all the things you'd expect, being a flip-flopper, an opportunist, a coward, but he insists this is what his constitutional thought requires. A few years later, the Supreme Court upholds the bank in the famous opinion of McCulloch versus Maryland by Chief Justice John Marshall that opens in the same analysis, actually, of liquidation and settlement. The court says, at this point, the constitutionality of the bank can't even be considered an open question. We, the court, haven't officially analyzed it and upheld it, but at this point, it's convinced so many people. Practice has settled its constitutionality, and then they go in to talk about it more. But they say at this point, it's barely an open question given the practice. It has been backed up by an exposition of the Constitution deliberately established by legislative acts. The same kind of rhetoric and analysis actually pops up, in almost every major constitutional controversy between then and now. Debates about the president's control over the executive branch, the constitutionality of libel laws in New York Times versus Sullivan, the steel seizure debate with President Truman in the Korean War, and so on and so on. But just to fast forward to a crisp modern example, that's part of what motivated me to start the paper. A few years ago, in a case called Noel Canning versus NLRB, the Supreme Court took a look for the first time at the president's power to make recess appointments, without Senate confirmation while the Senate was arguably not in session. Because the court had not looked at this before, the issue took place against the backdrop of 200 years of presidential and senatorial debates about the meaning of the clause. And one big question the court had was how to look at this, what it mattered for. And the majority opinion said, we think these practices, what the president and the Senate have been doing, can affect our interpretation of the Constitution now. It's different than it would have been on day one. Justice Scalia accused the majority of engaging in what he called an adverse possession theory of constitutional law, alluding to the property law idea that if I trespass on your property for 20 years, it becomes mine. When I was growing up, we had a neighbor who, whenever any of our visitors would park across the property line on her driveway, would always put an angry note on the car saying, "You cannot park here," because she was paranoid about losing her right to the shared parking pad. So, Justice Scalia says you're adversely possessing the Constitution. You're basically stealing it through prescription. And the majority responds, no. Actually, what we're doing was sanctioned by James Madison. James Madison said that practice could liquidate and settle the meaning of the Constitution. This was anticipated by the founders, and so what we're doing is not unfaithful to the Constitution. It's faithful to the Constitution. This is actually the first sort of real usage the Supreme Court has ever made of this phrase liquidation. So it caused a lot of people to scratch their heads and say, is this about Lenin? Is this a furniture store going out of business? Every provision of the Constitution must go. No. Right. So what is this liquidation? And as Harvey already alluded, it's an old idea, most famously put forward by James Madison, for how to deal with the problem of practice after the Constitution is ratified. And the most famous reference is in his Federalist Number 37, where he says, and pardon the quote, I'll try not to do this too much. He says, all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. So I just have to say, etymologically, liquidate comes from the Latin is to make clear, which is actually why we speak of liquidating or clearing off a debt. It is the same root as sort of to settle, to render unambiguous. Substantively, though, the idea, which might seem dangerously modern, is a recognition that the text alone can't settle everything, that there are always going to be some range of ambiguities, some set of cases where it's not clear one way or the other which side of the line they fall on. And so it's only after the ink is dry on the text and we have to actually get down to the work of governance that we can figure out, what it really means, what the exact dividing line, the right answer is in that range of possible meanings. Once we've had whatever kind of practice we need to settle it, that's when it's become liquidated. The meaning has become liquidated. So in the paper, I make two sets of arguments about this concept. One is to try to figure out how it works, and the other is to try to talk about why it's still a good idea and we should do more of it today. So first, how it works. There isn't a canonical statement of the mechanics of liquidation, but the idea pops up repeatedly over James Madison's public life, as evidenced from his own conduct in the bank debates, his own conduct in a series of debates. And he spends a lot of time defending himself against people who say, "What are you doing? This isn't faithful to the Constitution. We thought you were a believer," and trying to explain, why and when this kind of practice can come in. And so, as I've read through all of that materials, I think the idea boils down to three key steps. So first, there has to be a constitutional ambiguity. There has to be doubtful or contested meanings, as Madison once put it. The part where the text is more or less obscure or equivocal. And it's only within that range of ambiguity that liquidation can take place. If the Constitution's meaning is clear on some point, then no amount of practice can change it. Madison stressed that practice can expound the meaning of the Constitution, that is, flesh it out, but it cannot alter it. And so it's important to guard the line against practice being used to alter the Constitution versus merely being used to expound it. Second, once we have that ambiguity or uncertainty, we need to find a course of deliberate practice. Madison, again, had many formulations of this: a course of authoritative, deliberate, and continued decision, or more floridly, that which has the uniform sanction of successive legislative bodies through a period of years and under the varied ascendancies of parties. But the idea is we're not just talking about one time Congress or the presidency did something. It has to have happened, repeatedly to build up something like a tradition, and to be deliberate. So it's not enough that Congress has just done something, but that actually in the course of doing it, they've debated the meaning of the Constitution. They've made a claim about what the Constitution means that their actions sort of back up. So it's both actions and words. And then finally, that practice has to culminate in some kind of a settlement, meaning that it's not just still the same ongoing, say, partisan or institutional debate where the president keeps trying to do something and the Senate keeps sanctioning him, or the Federalists insist it's one way while the Democratic Republicans insist it's the others. There's got to be some sense in which the losing side has acquiesced or given up. Madison called this an evidence of the public will that necessarily overruled individual opinions, or again, a course of practice of sufficient uniformity and duration to carry with it the public sanction. And this phrase, the public sanction, actually tied all this back to Madison's own theories about representative government and popular democracy. The basic idea, at least the hope he had, was that each group of constitutional actors were going to be competing for the sort of rightful affections of the people. And so the president might make one claim on the Constitution, the House might make another, the judiciary might make a third, but ultimately for sort of power and safety in the constitutional system, they'd need the people's backing. And so the constitutional position that won out among those branches would be one that had some kind of a popular backing to it. Now, not the same kind of popular backing as a constitutional amendment, which is actually directly ratified by state conventions that have a more popular aspect to them, and certainly not what we think of now, an opinion poll or something dreadful about actual popular attitudes, but a sort of imputed structural popular support that if the branches had coalesced around this constitutional understanding, it had a kind of indirect support, which gave it sort of status as indirect constitutional law, the same way that a constitutional amendment might be direct constitutional law. That was the idea behind this public sanction. All right. When these three things happen, a constitutional ambiguity, deliberate practice, and a settlement, then the meaning of the provision has been liquidated, and the provision is no longer ambiguous. That's how much of constitutional law was made in the 19th century, from removal to the bank to the spending clause. The Supreme Court often didn't even get involved, or didn't get involved until matters are basically settled. Then there's the question of, what does all this mean today? So I come at constitutional interpretation as an originalist. I think that the law that the founders used to interpret the Constitution in 1787 or 1789 is still the law that governs its meaning today. So if liquidation was one of these legal principles of constitutional meaning, then it travels with the text, and it's part of how we should interpret the Constitution today, because it's part of the framework the Constitution was made law in the first place. So I think there's a strong originalist case to use this. But I think even if you're not a full-fledged originalist, and certainly in the circles I travel, most of my colleagues are not, even if you're not, I think there are a lot of other values that liquidation ties into. So one is that it's much more it's democratic. It invites constitutional reasoning and constitutional deliberation outside of the courts by the president, by Congress, by the states, so that representative institutions can be more involved in constitutional law, and we don't have a world where the only people who make constitutional law are unelected judges. Second, it fulfills a lot of the same role that things like judicial precedent do, but again, I think in a better and healthier way. So we have precedent for some of the same reasons, that we understand that you can't re-question every constitutional assumption if you're ever going to have a government that actually runs and functions. So you need some kind of stability. But precedent has the unfortunate feature of putting all of the settlement decisions in the hands of the courts. And at least in modern times, we let courts settle important questions with just a single case that might well be 5-4, deeply contested, wrong, and the Supreme Court just tells us all to shut up and get over it. Liquidation required a series of decisions, a back and forth with the courts and other branches, so that a matter was actually deemed settled only when in politics it had become somewhat settled. So it actually makes constitutional law line up with political reality more than the world the Supreme Court has constructed out of precedent. So in fact, in my more radical moments, I think maybe we could replace all of what we currently do with judicial precedent and letting courts be in charge of expounding the Constitution with liquidation instead. That would get us in the same kind of direction, the same kind of goals of settling the meaning of the Constitution, but in a way that really put courts in their place as one among equals, rather than the supreme governors of everything. Finally, as you can imagine, there are also sort of tradition-based arguments for this method of constitutional reasoning. The arguments for tradition are many, and I will not try to discuss them all here any more than I do them justice in the paper. But practices that have lasted a long time and that have gotten the sanction of many different groups and that we've all grown accustomed to are much more likely to be wise, or at least non-terrible, than things that are invented on the fly or that are developed anew. And so liquidated practices can have a lot of the same wisdom and benefits that tradition does as well. It's not to say that all traditions are set in stone, but again, liquidation can move us in that direction. I think that's 4. I don't remember how many I said I was going to do, but there's a panoply of reasons that I think it's a good idea. It's a good idea to use this. It can give something to everybody. So that's the basic pitch. That's the structure of liquidation and all the reasons it should be binding on us today. It'll just require a little bit of rethinking about the role of courts and the nature of the Constitution.
Wow. Well, thank you very much. There might be questions, I see. Yeah, Roger.
You described liquidation as making the court one among equals, and that seems to contradict my understanding of Marbury versus Madison. So I guess that will be the way of getting at the question I had during your talk of what is the relation of this concept and its history to Marbury versus Madison. And I assume, my other question was about stare decisis, but I guess your comments about precedent take care of that.
Well, I'll talk about it again anyway.
Okay.
So one, Marbury and judicial review. I think liquidation is completely consistent with Marbury. Marbury has been misunderstood and abused in the 20th century in a way that it's important to correct. So the big question in Marbury was, are the courts allowed to engage in judicial review? That is, can the courts look for themselves at the meaning of the Constitution, or do they have to take Congress and the president's word for it? If Congress passes a statute, do they just have to assume it's constitutional? And Chief Justice Marshall says, I think completely correctly, well, the Constitution is law, and what do courts do but look at law? You can't have courts and not have them focus on the law, and that means that courts will have to figure out what the law is, what the Constitution means, and interpret the Constitution for themselves. This, by the way, was actually uncontroversial at the founding in the debates between Hamilton and Brutus about the judiciary, whether it would be dangerous. Brutus says, you're going to have judicial review and the courts will interpret everything very loosely and ruin everything. And Hamilton's response is, well, yes, we will have judicial review, but I promise it'll be okay. But it's actually common ground that it will exist. I think Marbury holds that, and that's correct. Marbury contains this sentence that is sort of where things have run off the rails, where it says that it is emphatically the province and duty of the judiciary to say what the law is. And in modern cases, the court wants you to think that emphatically means exclusively, that it's our job and nobody else's job.
Your quote is from the Constitution here?
That quote is from Marbury versus Madison.
Oh, okay.
So Marbury versus Madison says it is emphatically the province and duty of the judiciary to say what the law is. And what they mean in Marbury is, it's our job too. You might have thought it wasn't our job. You might have thought that only Congress and the president get to interpret, but we get to too. So Marbury is where the court is taking its place, making clear that it's one of the three equals. It's not until the 20th century, and I think it's a tragic mistake, where the court takes the next step and says, we're not just first among equals, but we're actually the only ones who are allowed to interpret the Constitution.
When did the court do that?
Cooper versus Aaron in 1958.
He had an answer.
So this is the Supreme
Could you
Court
repeat
case.
the name of that? I'm not a lawyer,
Yeah,
obviously. But
Cooper versus Aaron.
Cooper versus Aaron, thank you.
It's the Supreme Court case that arises out of the Little Rock school desegregation showdown, where various members of the Arkansas government have been trying a series of dirty tricks to avoid having to comply with court rulings desegregating the schools. And the Supreme Court decides it needs to step in with an opinion clarifying what it calls settled principles of doctrine, which are in fact principles that it is now articulating for the first time, where it says that when the Supreme Court interprets the Constitution, all of the other branches are required to treat its interpretation as if it were the same as the Constitution. So the Supreme Court says our opinions are equal to the text of the Constitution. But that's the first time the Supreme Court has tried to make that move. And it's quite contrary to the original structure. We can talk more about it. I just want to say one thing about precedent and stare decisis. So those terms actually used to be distinguished. So it used to be that we would use precedent to refer to the idea of having a series of decisions, again, that had built up to kind of create a tradition. And stare decisis was the newer idea that a single decision could make precedent. The decision stands. We've ruled once, we're never going to rule again. And that's a change that happens after the founding, both in England and in the United States, where courts move away from, it used to be they'd say it's a sort of common law process, we rule several times, that builds up a tradition, and they eventually move to a more authoritarian model where they say, if we rule once, that settles things and it's the end of the matter. And they call that stare decisis. So liquidation, as I see it, is quite consistent with the old notion of precedent, but not the modern notion of stare decisis.
Which comes from
Those terms
Thomas.
still used.
Which comes from
Simon-
Thomas Hobbes. Sovereign.
That tells you what you need to know.
I'd like to follow up on what Gage asked. Would you therefore say, you seem to be saying that Cooper was wrong, and I'd like to ask, if you were Chief Justice of the Supreme Court and you are trying to prevent Jim Crow laws not to mention Plessy versus Ferguson, to say that was not liquidation, correct liquidation as it were. What would you do? It seems to me that you have just argued yourself into a defense of Jim Crow, not only in the South, but throughout the entire country. The rest of the country was not innocent of such measures. What would you do?
So this is actually not a hypothetical. So there is a behind-the-scenes debate at the court about how the court should handle Southern resistance. And here are the two models. There's the Cooper versus Aaron model, where the Supreme Court will announce in an opinion, our opinions are the supreme law of the land. Everybody has to obey right now and treat them as if they were the text of the Constitution. That's the path they take. Query how well it works, to be honest. They win in Little Rock not because of their opinion, because after all, if the South is willing to ignore one Supreme Court opinion, they're probably not going to pay any more attention to the second opinion that says, and we really mean it. They win in Little Rock because President Eisenhower backs them up, right? So it's actually liquidation behind the scenes. It's the president coming in and saying, I too share this constitutional vision that helps them get through. In fact, President Eisenhower thought that Brown itself was somewhat premature, but decided to acquiesce and to help liquidate the meaning. But there was an alternative proposed in some memos that are now available in the Library of Congress, which, as I understand it, was favored by Justice Black, although I'm not as positive that he was the one. And the idea, so this is the non-liquidation, or this is the liquidation model, the non-judicial supremacy model, was to do it piece by piece. So even without judicial supremacy, in a particular case, the federal courts still have the power to decide the constitutional question and to order any remedy they think is appropriate. That's judicial review. That's Marbury versus Madison. So they would get a case just dealing with the Little Rock schools, and they would say, you have to desegregate right now because you're the actual party before us. That's what we can control. And you've got to do it in a week or whatever, or else contempt and all the full range of sanctions will come down. And so rather than try to sort of rule everybody at once right away, you could go after a few at a time. Some advantages of this are when the court tried to go after everybody at once, it then realized it couldn't actually demand that the entire South desegregate immediately. So it had to start walking back and saying, well, you don't have to do it right away. You have to do it with all deliberate speed. How fast is that? Not very. And how much control did it have? Not much. Whereas if you proceeded case by case, what you're doing is letting the plaintiffs decide, this is the battle we want to pick. The court actually has the resources to go in and enforce the law there. You settle that one, then move on to the next one, then move on to the next one, and like dominoes, they eventually start falling. That's not the path the court takes, but I'm not convinced it would have been any slower than what actually happened.
I think we would still be desegregating a school in Florida, and we'd be looking for the next one in South Carolina. I think there would be all deliberate slowness.
I guess I will say, we are still desegregating some of those schools even now under the old regime. So it's not like we're dealing with a counterfactual world where the Supreme Court spoke and we all...
Just measuring quantity of resolutions.
Sure. The idea of liquidation is that if you can pick enough battles and win them, then that will actually be a better way of bringing around settlement than the Supreme Court just trying to announce it over and over again to people who disagree. That may not be right, but I'll just say that's the...
Do you not underestimate the spirit of resistance, locale by locale?
I grew up in Indiana, which has the highest per capita membership of the Ku Klux Klan in the country.
Yes.
Thank you for your paper, and I look forward to using, instead of the verb clarify, liquidate, and see the look of confusion or fear in my interlocutors' faces.
Ironic.
But I guess my question, I first have just a historical question, which then bears on my point, which is, I thought you said that the use of liquidation was only revived recently in this Noel Canning case. But then you made it sound like, in fact, it was applied throughout the 19th century. And so I'm kind of wondering, is this something that is part of the living tradition, or is this attempting to revive something that Madison, a very smart man, wrote extensively about, but really never was lived. And that would bear then on, should we apply it on its own grounds, which is that it would be part of settled practice. So that's my basic question, and as part of kind of pushing back in some of the ways that others have done here, which is that if the three parts of liquidation, an ambiguity, a practice, and a settlement, those seem to me to be very open to constant debate and discussion. I mean, law professors or lawyers could come up with plenty of ambiguities, equivocalities, and such. Practice, as you point out in the paper, President Jackson picked his points of practice that he thought were important about the second bank versus others there. And settlement in such a large and bustling nation, I mean, there are always going to be people, a significant number of people who are going to be on the other side of whether it's desegregation or anything else. So it seems to me, you could make the case that from practical judgment point of view, not just technical grounds, that this would be a very unwise instrument to revive.
Yeah. Okay. So, in oversimplified terms, so liquidation is a common practice of the founding. At some point, I think the word drops away and some of the specific mechanics drop away, but the basic idea remains very common. So the idea that a course of practice will be given some weight, and it pops up in different guises. So in Youngstown, the steel seizure case, Felix Frankfurter writes about historical gloss, or the gloss which historical practice has written on the words of the Constitution, which is a similar idea. There are things about that framing I think is not as helpful, but it's kind of picking up on the same thing. So I think there's a practice of liquidation that slowly we kind of lose a little bit of sight of exactly why we're doing this and how it works. And then the rise of judicial supremacy and the rise in the second half of the 20th century of the idea that really the courts are the only ones in charge sort of further diminishes that practice, although it doesn't totally fall away. So there are still a huge range of constitutional questions which don't go to the courts and are largely resolved inside the executive branch, where executive branch lawyers write very serious opinions in the Office of Legal Counsel, analyzing and distinguishing previous opinions that draw on historical practice. So even now it remains a part of how people think about it, but it's sort of both the terminology and the structure we've really lost sight of them. So I think for this to be right, for this to be non-dangerous, part of what we have to hope is that we kind of can never get away from this. It's such an innately good idea to care at least a little bit about practice and tradition that we've never totally stopped. But part of the reason it seems so unwieldy and so hard to imagine it working in practice is we have lost sight of why we do it or exactly how it's supposed to work. And so at the moment, it's sort of like we've got like the vestiges of this practice, but we're kind of fumbling in the dark looking for how it makes constitutional law. And if this is right, then maybe it provides a way to kind of get that practice back, both to be a more serious and respected part of constitutional practice and to have a little bit more structure to it, so it's not just kind of the amorphousness of like history and stuff. Maybe that's too ambitious, but.
When you were giving your talk, I was thinking, to what extent does this describe desegregation? And the previous discussion had said, no, there's this difference between judicial supremacy, Cooper versus Aaron especially, as a opposition. But it strikes me that what you were describing did describe desegregation. Number one, because the Constitution wasn't clear. And just parenthetically, I said that Brown does create a problem for originalists. It created something of a problem for Justice Scalia. So this is a way of trying to blend originalism with your understanding of the limited role of the courts. But after Cooper versus Aaron, there was no desegregation really. Maybe Central High School, they said, but there wasn't, so it really didn't resolve the issue. But it was Congress, it was HEW, it was the Fifth Circuit, it was what happened in school district after school district. So I was wondering, would you describe desegregation as an example of what this liquidation in practice?
Finally, a friendly question. Yes, no, this is exactly right. So to borrow again on the prestige of my colleagues, Jerry Rosenberg has a book called The Hollow Hope that documents. Now people fight but documents. I think even if he's wrong about the general thesis, I think he's right about this case that in practice desegregation happened not just when the courts said so, but when the executive branch and Congress joined on board and said, okay, we'll actually make this happen. And that's the sense in which I mean that liquidation is actually more realistic than the idea of judicial supremacy, that in fact that's part of what makes the constitutional meaning settled. Now, I'm not willing to concede that there was an ambiguity. I'm actually not. I actually think Brown was right, and maybe even unambiguously right. There was, of course, a long period of history in between where a lot of people disagreed, and you had Plessy versus Ferguson. That's, I think, the thing I really worry about is, should we see the previous period, the rise of Jim Crow and redemption, as also a form of liquidation and a reminder of the dangers of liquidation, that the 14th Amendment had a lot of ambiguity in it, and the South took that ambiguity and ran with it. And it was only sort of some unusual events that allowed us to break free of that. That's the period I worry about, just to turn the friendly question into a hostile one. But I actually think the success of Brown and the civil rights movement shows that you need all three branches to make constitutional law.
I just, to continue some hostility here, so, it can, Brown can be unambiguously right, but hard to justify on originalist grounds.
Yes, I mean, when I say unambiguously right, I mean even on original grounds. But I know I'm
Minority.
yeah.
Yeah, but you're not differing from Michael McConnell. He would also agree on originalist grounds.
A minority is okay if it's good company.
So, can I follow up?
Yes,
please. So, first of all, I just think it's a great credit to the University of Chicago that they've asked you to join their ranks. I was there, and while I was there, I studied in the government department with Herman Pritchett, who wrote this book on the judicial system. And actually, this was his, there's two criticisms of all presentations. One is you're wrong, and you've heard that one, and the other one is we knew it already, right? So I want to get the other side out there. And so I think if you read that book by Mr. Pritchett, you will discover that he does acknowledge that the Constitution is written by all three branches, not just by one. That's not to criticize your point, that's just to say, and it's a good thing you lawyers are starting to realize that what political scientists have long known. So that would be my first observation, and the second one would be, as I understand the Brown decision, Earl Warren tried very assiduously to avoid overturning Plessy by distinguishing the transportation system of Louisiana from the schools of Topeka, Kansas. And he says that it's in the hearts and minds of little children that if they're segregated into black and white schools, it creates a sense of inferiority. As a lot of psychologizing that it's not very persuasive, but it does allow him to distinguish. And so, in fact, after that, decisions handed down in Montgomery when Martin Luther King, Rosa Parks and the buses and so forth, the police chief in Montgomery says, well, Brown doesn't say anything about buses, it only says something about schools. And so I see Cooper as really addressing that problem, extending it, but extending it only in light of the fact that the other branches of government have come to the support. I mean, why do they say deliberate speed in the first place? It's because they're looking for liquidation. They're inviting liquidation. So, I think you're exactly correct. What I don't quite understand is why Cooper is such a, why you're so critical of Cooper when really they held back with that kind of phrasing until they had seen that there was political support for their ideas.
Okay, so a couple things to unpack. So you're right that one of the sort of moves in Brown is to say education is different, education is special. It is then a move that the court quickly backtracks on, so they just get a series of cases involving parks, buses, and they decide them in like one-sentence opinions with no reasoning that say, reversed, see Brown. So in Brown, they say it tells about education, then they get cases about non-education, and they say, oh, actually, this is the same. So it's a one-line opinion called Gale versus Browder that actually reverses Plessy versus Ferguson and says, the same principles apply to transportation and everything else. It's a little bit of sleight of hand, maybe to start with education and then add other things. But another piece of the strategy in Brown that I think is relevant here is that Earl Warren cared a lot about making sure the opinion was unanimous. And he made clear early on that he wasn't willing to go forward with anything other than a unanimous opinion. And there was a Southerner on the court, Justice Clark, and it was really important to have him on board so as not to send any sort of sense that there was a divided front, which I think is sort of related to this. The court is trying to say this is not just a 5-4 decision, it's a flash in the pan. This is the new regime, at least judicially. And so Cooper actually also has a little paragraph in it that addresses this point that says, there have been 3 new justices appointed to the court since Brown, and we just want to make clear that all 3 of them also agree with Brown and that we are not backing down. So one of the questions, I think, is just, is 4 years of Southern resistance going to cause the court to back off? And that's where they're making clear, while we said all deliberate speed, we're not backing off too much. The thing that Cooper has to do, that it's the part that bothers me, and maybe it's too technical to bother most people, is the court in Cooper has to reach out to people who are not parties to litigation. So the litigation is between the Little Rock School Board and the students who want to attend, and they've been going back and forth, and the school board's been obstructing, but the court reaches out to say, we want to address the governor and the legislature and other people who we know have been critical, but who are not actually part of litigation, and tell them they've got to stand down and stop it right now. Like, they haven't even been sued, but we're reaching out to the whole country to tell them they all have to acquiesce. And that's the move that worries me, because I think that's the move that then makes the court feel compelled to tread so softly. In my vision, and I'd say it's the original vision, federal courts are actually unafraid to enforce the law sort of fully, even against recalcitrant parties, but they can do that because they're focusing on the parties, and they've got sort of like one concrete dispute before them where they actually have a chance to make sure the law gets enforced. And the more they spread themselves out and try to rule the whole country at once, then the more they have to moderate themselves and rule more slowly, and they lose sort of whatever particular force they have. On the we knew this already. The only thing I can say is James Madison knew it all already too. So if the biggest defect in this paper is that it was entirely preempted by James Madison and he deserves all the credit, I am happy to let that happen.
Yes, Tom.
You knew Justice Roberts, of course, and I just wondered if you think he had in mind your flexible structure here that you're saying is a good idea when he sort of made law twice and rubber-stamped Obamacare.
I'm positive he's not accountable for anything I say. I don't know whether I reverse. I don't think so. I think so. There is, and this is maybe a little bit of what people are worried about. So in the main controversy in the court's decisions upholding Obamacare, especially the first one, NFIB versus Sebelius, is the court's sort of straining to find the statute to be ambiguous, where it's maybe not so ambiguous at all, and straining to uphold it on grounds that were not the ones Congress thought about, and indeed, on the contrary, ones that the president denied on national television. It seems like the principles of liquidation kind of cut in the opposite directions. So for liquidation, while ambiguity is a key threshold, that only works if we don't totally manipulate what's ambiguous. If you can say anything is ambiguous, then the theory is very dangerous, because then you can always get away from the text. Madison tried very hard to fight that, tried very hard to say, there has to be an actual ambiguity. You can't go around changing the Constitution under the guise of ambiguity. And he has a series of other, arguments about constitutional interpretation that you can't. Even though he says it shouldn't be interpreted with the strictness of penal code, he actually specifically rejects the label strict constructionist. He says, don't go down the slippery slope the other way and construe it with a laxness of character that would allow the court to uphold anything no matter what happens. And this is a little more tangential, but again, the emphasis in liquidation on constitutional deliberation in the other branches, giving credit to Congress's and the president's decisions about constitutionality, might make us nervous about upholding a statute on grounds that Congress and the president rejected, right? That the idea of liquidation is to say they thought about this constitutional question, we'll give them some credit for that, in cases of ambiguity. To do the opposite, to say, well, they thought about this constitutional question, they specifically waived this constitutional argument, but that's the one we're going to use to pull this out, I think actually would make Madison very, very nervous.
Take a rest.
So I just want to make sure I understand like with liquidation when it with regard to the Supreme Court ruling against another branch. Like for instance, with Ex parte Merriman, Lincoln noted how Tawney didn't. There was this sense of ambiguity that Tawney didn't exactly say how he should act in his July 4th address, and then retroactively Congress approved of Lincoln's previous action. So obviously, like the ruling was against Lincoln, but then Lincoln defended himself with this sense of ambiguity, and then Congress retroactively approved of his action. So is that liquidation still, even though it's kind of two branches teaming up against the Supreme Court to defend one of the other branches?
No, that's a great question and a great scenario. So I think to say it was fully liquidated, this would be the start. We'd say, Tawney made a contestable constitutional interpretation. The president and the attorney general took the opposite view. Congress backed up the president. I think then we'd need the third step of acquiescence. So we'd need to see the courts then also, to some extent, giving up and adopting the president's view. There are some subsequent habeas cases and fights between the president and the other branches, and people fight about exactly how far they go and whether to read them. I don't see the court as sort of beating the kind of retreat you'd want to see the third one. Without that, then we're still at the stage of contestation. If it's just, two branches still fighting what it means, neither one of them can yet say, we're right because we are engaged in practice, because the other side is also engaged in practice. So we need to see if one of the two kind of acquiesced and gave up. And there's some hints of that and some stuff Tawney does, but I'm not sure it's all the way there.
Yeah, Rory.
I don't claim to understand originalism that well. I've always been suspicious of it. My reaction to the gist of your talk, in a sense, was that you found in liquidation a bit of a sigh of relief in being an originalist. You can be an originalist, and thank goodness you found another originalist, Madison. Original, he's just an original, and he has this theory, so that's helpful. I wonder. And I wish I could phrase it with references to all these famous cases, but I can't. One almost starts to suspect that Madison was not an originalist, if I can put it that way. And in liquidation, it points towards a kind of fundamental problem of the interpretation of law, and not, it's a strange thing to find in an early or original understanding of the authors of the Constitution. It seems they are signaling a limitation on constitutionalism generally. They happen to be the founders, but that doesn't. There seems to be this issue, and so I wonder if liquidation, to the extent that it's helpful for an originalist position, it also calls into question the full coherence of originalism, which may be the full coherence of constitutionalism, not of originalism.
Okay, so Madison gets the accusation of not being an originalist a lot, and I'll say part of the goal of this paper is to defend his honor. So there are a lot of people who say, the whole episode of the bank just proves that even Mr. Originalist himself couldn't live up to his principles, and he, bowed to pressure. And we could disagree with him, but I think he was consistent the whole time, and that's part of why it's important that he sort of lays out this idea. In arguing for the Constitution, when people point out that the Constitution has some ambiguities, right, in the Federalist, he could say, oh, no, it doesn't have ambiguities, here's what it all means. But he doesn't. He says, yes, it has ambiguities, and some of them, we're not going to find out what they mean until later. And that's just the way law works, the way language works. I think a lot of Federalist 37 is really like cribbed from Locke, but, that's Madison sort of backing it up and saying, even before people have ratified the Constitution, this is what you're signing up for. So I do think Madison's consistent, and if the person who is the father of the Constitution and promoting the Constitution says this is how it's going to work, what could be more originalist than to do that? Like, how can you be more originalist than the founders or more Catholic than the Pope? Reference, it's slightly dated now, unfortunately. But and I guess, so I do think you're right that it does maybe show the limits of what we might hope for from originalism. So if the dream was that originalism was going to supply the objectively correct answer to every question so that we wouldn't have any danger of willfulness, we wouldn't have any ability of judges and other people to subvert things or find ambiguity or go rogue, I don't think originalism can do that. James Madison didn't think originalism could do that, and I think it can't do that. But maybe that's the wrong thing to hope for. Maybe it can still resolve a bunch of questions, limit us to some questions that we still have to work out, and then tell us how we're going to work them out and how to go forward. I'm a glass half full guy, but that's my half.
Yeah, yeah.
Well, your last answer makes it sound like Madison was saying, we need to pass this Constitution to find out what's in it. Just two questions. One, in your paper, you focus on the need for a course of deliberate action, and I'm wondering why that's the case. I mean, sometimes we reveal more about our understandings of the world when we don't explain what we're doing, right? Maybe when Congress isn't saying what it understands, it reveals what it implicitly understands. So I'm wondering why deliberate course is so important. And second, I'm wondering, can a liquidated text be unliquidated and reliquidated? Is this sort of a once and for all exercise? And the example that came to my mind, you ran through a quick list of things that were liquidated, and one was removal, the power of Congress to limit the president's power to remove officers. And that seems like an example of this. Or in the early period, arguably, they liquidated an understanding of the president's removal power where he had full authority to remove officers. And you get to the Tenure of Office Act after the Civil War, and Congress is pushing back against this, but it's very controversial. But then in the long run, in the early 20th century, we get independent agencies, and Congress codifies these restrictions on the president, and now, almost a century later, we seem to accept it. I'm wondering if that's something that was liquidated, unliquidated, and reliquidated.
Okay. Reliquidated, and the first one was?
About deliberate.
Yeah, okay. So deliberate is one I am less sure that it's a necessary component, but it was important to Madison. And this may be a difference between liquidation and some of the kind of cousins that grow up. So to Frankfurter, I think practice speaks louder than words. He doesn't really care what anybody thought about. He just wants to know, like, how have we been doing this in practice, and then we'll find out some way to justify it under the Constitution. Madison thought it was, like, there had to be deliberation, because he said, just looking at even the reality of governance then, sometimes we pass a bunch of laws in a hurry and aren't really thinking about the constitutional problem at all. Like nobody realized it was there, and we don't mean to establish some new constitutional principle. If somebody reminded us, we might have acted differently. I suspect, and now I'm going outside of my scholarly brief, but I'm going to do it anyway. I suspect Madison is also writing from an autobiographical place, which is that in Congress, it frequently happens when Madison is in Congress, that a bunch of his colleagues decide to do something very popular or very politically tempting, and then he is the one to be annoying and stand up and say, but I'm not sure the Constitution gives us the authority to grant disaster relief to Haitian refugees, or I'm not sure it gives us the authority to grant a subsidy to the codfish industry, or whatnot. And then and then his colleagues listen, and then sometimes he can come up with a workaround, but he sort of insists on paying attention to the constitutional niceties. And it often seems like he's almost the constitutional supervisor, and like a lot of people would have just kind of done stuff. And that had been the regime under the Articles. The Articles of Confederation were more strict than the Constitution in lots of ways, but the actions Congress took were in many ways more lax. They frequently just did stuff that wasn't even plausibly justified, and then afterwards said, well, we had to. So in the Articles, they passed a bank, and when Madison was asked about this later in the national bank countries under the Constitution, he said, well, that was the child of necessity. Nobody thought that was actually, lawful. So I think, there's some uncertainty, some risk we're going to fall back into that world where the Constitution is just like a thing we keep in the archives and don't actually worry about. And he's trying to say it's got to be, we've got to be doing more than that. Unliquidating and reliquidating, I think it's a really hard question, and one where obviously it's harder to get an answer from Madison himself because he's focused on a shorter time horizon. And so he both talks about, how we're going to permanently settle things, but he talks about some other things. If you really follow this analogy to precedent, which I'm kind of wedded to, and which Madison does talk about a lot, then I'd be inclined to say it's like precedent. So the court can settle precedent one way, and then in the right circumstances, it can overrule itself and settle precedent the other way. And I'd be inclined to say liquidation's the same. Now, it makes me very nervous, so I don't just want this to all be a soup of kind of it's one thing, then it's another. So I think we'd have to have very, very limited circumstances under which practice could change from one to another. And even in things like presidential removal, right, in the end we don't. In the end we have a presidential control for a while. We have the blip of Andrew Johnson, where Congress really hates him for other reasons and goes after him and tries to limit his power. Even then, they fail to impeach him, right? And then the next presidents kind of back off, like the next presidents, they repeal statutes some, and then by the time the Supreme Court gets around, it takes the executive power position again. So we don't even really get this like one to the other. The only one I can really think of, if we think it's ambiguous, is sort of from redemption to Jim Crow, or from redemption of Jim Crow to Brown. And it does seem to me maybe that's a reliquidation, and maybe one that's got to be right. But I think those have to be really rare.
Yes, Professor
I
Wang.
would two questions. Number one is that it seems that you are saying these three branches have equal say regarding the meaning of the Constitution. If that's the case, when the Supreme Court made the decision, the other two branches does not follow it, does not, enforce it. What can be done? What can be done? I mean, it seems to me that when Hamilton and John Marshall argues for judicial review, their argument is based on the different nature of these three branches. Why the judicial interpretation of the Constitution is preferred is because it's different from the two other branches. It's not influenced by the people, by the public opinion. So that's why they think the judicial interpretation should be preferred, should be better, more unbiased, so more impartial, things like that. When you argue that they have equal say, it seems that you don't think that they have a different nature, at least to some extent. That's my first question. The second one is that you said that the liquidation requires public sanction. So if that's the case, well, how do you deal with the problem of the tyranny of majority? If the public sanction means that more people, majority, or even supermajority, so agree with you. So but this still could be wrong. This still could be a disaster for society, you know. So what's the limitation to the public sanction? I mean, is there any limitation to that or no? So
Yeah.
I guess that's that.
Okay, so first on interpretation. So while we now say things like the judiciary will be impartial, they're above politics, none of that's in Marbury versus Madison. Marbury versus Madison's argument is we take an oath to the Constitution, and that means that we are entitled to interpret the Constitution. Well, so do members of Congress, and so does the president. In fact, the president's oath is so important, it's spelled out word for word in the Constitution. Nobody else's is. So just in Marbury, historically, the court is at pains to say, we're like the other branches. We know they can interpret the Constitution, but we think we can too. This idea of sort of being removed from politics as being a reason to give them constitutional law, I think at the time would have been thought to cut both ways. Because on the one hand, that makes them freer from politics. On the other hand, that makes them look a lot more like the monarchs that they were rebelling against in the first place. Right? An independent judge could be wise, but they could be a tyrant. Now, we do have the problem of what happens if the courts rule, can the other branches ignore them? So the idea was not that. It was that each branch was supreme in its own sphere. So when the court is deciding a case and deciding what remedy to order for the parties in front of it, that's the court's job. They're supreme in that. They get to issue a judgment that you have to pay me money or an injunction or whatever it is, and the president and Congress can't overturn that. When the president decides to grant a pardon or to sign a law or to veto a law, he's making his own constitutional determinations, and the courts can't step into those. When Congress decides to, et cetera. So the idea was each of them have a sphere of activity where they are supreme, but nobody controls the whole field. Nobody can say, we control all of constitutional law and everybody has to agree with us. They each have particular areas. And so liquidation happens when those line up in all the different areas. And the courts are ruling, and the president's enforcing, and Congress is passing, and they're all similar. But that's the sort of the old balance of powers. People argue whether it's unstable. Maybe you can imagine places where it's unstable, but that's the theory for working it out. As the public sanction, just quickly, one limit is ambiguity. So again, no amount of public sanction or liquidation can trump the constitutional text. That's the supreme law of the land. As for the tyranny of the supermajority, like what if the people pass a constitutional amendment that's terrible? Nothing can save us from that.
Dimitri.
Thank you. I suppose it's a bit of ancient wisdom that custom interprets law and amends law, and so a virtue of this account is that liquidation is a much better way of getting at custom than is a single judicial precedent. My question is about just that last point you made. So it's about the first prong of the test, the ambiguity test. So presumably there's a difference between a bit of the Constitution being ambiguous and interpretations of that bit of the text being contested. So Madison, I don't know, suppose that Madison at the time when he first opposed the National Bank thought it is absolutely clear there is no ambiguity, the Constitution does not permit this sort of thing. That was clearly a contested view, he clearly lost that view, and then however many years later he came back and the view was still contested. But presumably, if originally he thought the text was clear on the question of the constitutionality of the bank, then the fact that the question had been contested and decided against him doesn't change the unambiguous reading of the provision. So I just wonder how this case, how that fits.
Yeah, no, this is great. And this is now something people wrestle with in the modern legal literature is they sometimes say, is ambiguity subjective or objective? Like, is ambiguity just, well, you and I disagree, so it must be ambiguous? Or no, it means this, it's unambiguous, you're just all crazy, right? Which way do we think about it? I think you're right, although I'm not positive, that Madison had the second one in mind. So that it's not just like, is there disagreement, but it's like an objective quality of the text, whether it's ambiguous or not. And that raises the problem you describe. And I think you're right, if it had happened like that, if Madison had thought the text was unambiguous in saying no bank, then I don't think he would have been entitled to change his mind later. He thought it was ambiguous later, and if you look at his bank speech, actually, while it's very passionate about why the bank is going to be terrible and that it's unconstitutional, it actually does kind of concede the question is ambiguous in several places. So he lays out a bunch of principles of interpretation that he thinks should be used to construe the Constitution, and he even says these are principles for construing the Constitution when it is silent or when it is ambiguous, because he has to admit there is no national banks clause in the Constitution. There's a bunch of powers given to Congress, and the question is, do any of those powers stretch far enough to reach the bank? And then there's the necessary and proper clause, which allows you to stretch those powers even further. And so he says, actually, there's an ambiguity. My opponents are attempting to stretch that ambiguity too far. I don't think this is within the zone. But I actually read the speech to concede some kind of ambiguity. If you thought it was unambiguous, if you thought this is definitely unconstitutional, then under Madison's view, no amount of practice would change that. You would still be the crank even when everybody else was against you.
Anna.
I'm no expert in this field whatsoever, so I have a very basic question. Can you explain to lay people a bit more what different kinds of ambiguities are and why Madison even allowed for them? Is it just a necessary evil? Was it the result of compromises that had to be done? Is it because you just can't cover most of the stuff? Or was it deliberate in many ways to allow for something? This is in Rory's and Adam's vein a little bit to allow for a bit of breathing room.
Yeah, no, great. Okay, so in modern parlance, we would often divide things into two different kinds of ambiguity. One which we'd call ambiguity, like a word kind of could have two different meanings, we just maybe didn't pick quite the right word. And one which we'd sometimes call more like vagueness. You picked the right word, but there's just, you can't be totally precise about it. Like when, hot and cold, but like what's the temperature that moves from hot to cold? Nobody quite knows, and it depends on, in Madison's terms, in like more practical terms, I guess I see it there being as two kinds of ambiguities, maybe one of which is a necessary evil, one of which is necessary and might not even be evil. So one is the unforeseen circumstance. We adopted a rule, but we can't anticipate every way it's going to apply, and there will sometimes be a time we have to apply it where it just doesn't quite fit. This doesn't fit the thing we were deciding, and so we've got a little bit of ambiguity. Like if we have to ask whether or not some very new question are cell phones or electronic data like covered by the Bill of Rights as a form of property or papers, and there's an ambiguity because it's an unforeseen circumstance that the framers just couldn't have been explicit about because they didn't even know it was there. That's sort of the necessary evil. The second kind, which is a little more like theological than I usually go in for, but seems to be part of what Madison worried about, was there's just an inherent limit on what words can express. And this is in Federalist 37 too, that we think in terms of ideas. We have ideas in our mind that might be perfect, that might be exactly what we want, but words don't actually totally match them. And it's just like not a property of human language that it can precisely express everything about the perfect idea in our mind. Maybe God can do that, but man cannot. And that's, I say, necessary. I'm not even sure they would regard it as an evil, because that's like built into the limits of mankind and the difference between the divine and then maybe that's the way it is. But that's the other kind of ambiguity they deal with. So they're trying to set up the separation of powers, and they write a bunch of provisions and ideas for how it's going to be, even if they have in their head a perfect idea of the separation of powers and ideal governance. No document of any length could spell that out, just because of the way words work. Like, you can't keep adding words; they're just too messy. And I think he packs both of those in as different kinds of ambiguities, where we have to work it out in practice.
Yes.
I'd like to, excuse me, I'd like to put a question to you. Let us assume that you and I have identical notions of justice. A case comes up comparable to the Indian removal case under Jackson. And we say, to the Indians, well, I'll tell you what. When the president agrees, Congress agrees, the legislature of Georgia agrees, and the Carolinas, and popular opinion comes around to your way, we'll do that. But until we'll liquidate the meaning of the Constitution. But until that comes about, you have to suffer whatever the government doles out. In other words, your argument is one that justice delayed is not justice denied, it is merely justice postponed.
I don't think so. So I think we'd say, in the meantime, I mean, liquidation is not the first line of defense or the first thing in any constitutional debate. The first thing to do is to try to get the Constitution or whatever the question is right. Liquidation is going to come in later, but if we haven't yet reached the point of everybody being settled, like, whoever it is in charge is supposed to correctly interpret the Constitution, whether we think morality is part of that or not, whatever it is. Liquidation only comes in fact, if we've been making mistakes. If we've been doing the right thing, we never have any need for liquidation, because the Constitution, we're on the first line of constitutional law. Liquidation just says, if we've been getting something wrong for a long time, under some circumstances, we'll just decide to live with it. So it's more like, well, I won't try to reverse the metaphor, it's going to get out of control. But it's more like, we should always try to do justice in the first instance. But sometimes, after a while, in a case of ambiguity, we just accept that this has become the practice, even if it's not perfect.
Andy.
Thanks for your talk and paper, Bob. I wanted to ask you about the second half of the 20th century and some of the controversies and how your reflections on Madison's liquidation would affect your recommendations to the court and to the country as to how to handle them.
Do you have any in mind, or do you want me to?
I was going to ask you to pick one or two that you think would help us understand the way that you're looking at the questions. I didn't intend to provoke on a specific controversy.
Yeah.
Pick abortion.
So, or same-sex marriage. Say something.
We could do them together. Yeah. So. Right. So we have these cases where the Supreme Court is called to step in on a major culture war issue where people disagree. Under the way the court currently thinks about it, and I think they talk about this at the most length and the most explicitly in Planned Parenthood versus Casey, where the court reaffirms-ish, with some modifications, the right to an abortion described in Roe versus Wade. People calling for it to be overruled, people calling for it to be kept. And the court says, what happens is that the Constitution asks the Supreme Court to bring the nation together and to speak to the nation with one voice and call us all to set aside our differences and rally behind a single answer. There's a whole bunch of rhetoric. Like, the people find the meaning of life in the ability of the Supreme Court to tell them what the answer to a constitutional question is in this case. and so on. And they even actually talk about this idea of sort of does resistance matter? And they say, it's true that Roe versus Wade has become more controversial over time. People are protesting. That's extra reason that we have to hold the course, because liberty would find no refuge in a jurisprudence of doubt. People would feel unsafe and uneasy if they knew that the Supreme Court ever cared about what they think about anything. So that's not very liquidation-like reasoning. That's, if anything, the high point of the opposite way of thinking about the court's role. I mean, we could talk about the merits of constitutional law of abortion, but even just thinking on the jurisprudence level, like that kind of attitude that the Supreme Court's job is to take a whole controversy, rule in one controversial case, and we will all, take it and like it and get over it, is the opposite of the Madisonian view. And I got to say, in practice, things look more like Madison's world than the Supreme Court's world. It's not like the Supreme Court's ruling in 1992 caused the abortion controversy to go away, or caused people to stop disagreeing, or to stop making it a major issue in confirmation hearings. If anything, it seems like it's an even bigger issue in constitutional law than it used to be. So that's the idea that practically it might not work that way. So I think the liquidation version, the court might still rule the same way. I mean, they should figure out whether they think there's a right in the Constitution or not. And why. But then part of the question would be, over time, do other people buy it? Do states and the Congress and the president all sort of eventually line up behind it? And if not, then we're still fighting about it. We're just not in liquidation world either way. We aren't telling, we're just still trying to figure it out. Interestingly, same-sex marriage actually looks a little different. So even in the very short time the court had to start dealing with this in Windsor and Hollingsworth versus Perry, and then to come back a few years later in Obergefell, the court noted that sort of states were lining up to all switch sides and to sort of join the right to same-sex marriage, to accept court decisions against them. There's even like an appendix in Obergefell listing all the states that have acquiesced. The whole thing only started because the president joined the constitutional challenges to the Defense of Marriage Act. So actually the court, it looks a lot closer to the Madisonian picture. I think, maybe it still goes a little faster. I'm not sure if Madison were asked these questions about the constitutional right to abortion and same-sex marriage, he had a lot of questions about how we even got here. So I'm not saying, that. But I'm just saying the second picture looks much closer to the kind of constitutional vision. And the abortion politics one looks kind of like a failure.
Yes.
It strikes me as odd that up until right now, I felt like the states as actors in the constitutional game were kind of left out. But the first half of the 19th century, they were very much involved, and there was this back and forth with the federal government. So I was curious, especially for Madison, who had an idea of states being actors, maybe not as strong as Jefferson's, but other than states just acquiescing with whatever the Supreme Court or any of the federal branches of the government rule, is there room in here for interposition? Is there room in here for state Supreme Courts to be able to duke it out in the realm of ideas with the federal Supreme Court? What role do the governors, the state legislatures, do the state Supreme Courts play? And I'm saying this even knowing that Madison would not have predicted that senators would be popularly elected and would be instruments of the state government. But what role do they play?
Yeah, no, I think definitely they play a role. So one of the other great early constitutional controversies we haven't talked about yet is the Sedition Act, passed by Congress, enforced by the president, enforced by the federal judiciary, but ultimately not liquidated and liquidated to the contrary, partly because of the states, partly because the Virginia legislature and the Kentucky legislature, at Madison's and Jefferson's urging, passed resolutions condemning the Sedition Acts, and then get other states sort of fighting back and forth about whether the national government is abusing its powers and suppressing dissent. But Madison is like at the helm of the state resistance. It's not quite interposition, like the state isn't actually sending officers out there to free people or to try to obstruct the enforcement of the federal sedition laws in quite the way that happens later. But the states are definitely a player. And then in 1800, Thomas Jefferson is elected, in part on an anti-Sedition Act platform, and he pardons everybody, and Congress repeals the Sedition Act, and everybody acknowledges it was a big mistake, and if anything, sort of liquidates the unconstitutionality of the Sedition Acts. So I think they definitely get to play a role. Exactly how far it would go, I think, is the more worrisome question. So Madison actually deals with this as president too, because there are riots in I think it's Pennsylvania over some admiralty case that's become very controversial, and he's like called out. The state actually calls him out and asks him to send troops to support them because they think, as Mr. States' Rights, he might be willing to help them, resist a federal court judgment. And he says, no. The Supreme Court is supreme in its sphere. So if the court has ruled in a specific case, the states still have to go along and still have to acquiesce. And as president, I have no power to stand in the way of a specific federal court ruling. So there's a kind of negotiation about exactly how far the states can go, and they get to say these opinions are wrong. We don't agree with these principles, but they wouldn't get to actually resist in a particular case.
When you said that Roe v. Wade was a failure of liquidation, what does that mean? That you regard it not as settled law but as unsettled law? Would that be a better description, or what?
Yeah, I mean, surely that's true. I realize everybody who's up for a judicial confirmation has to say it's settled law, and it is as a matter of precedent. It's true. The Supreme Court has ruled. They've ruled again. There are a bunch of cases about it. But the whole reason it makes everybody so nervous, the whole reason we ask all the judicial candidates about it, is because we know that we're not sure whether it's settled. Right? Everybody on both sides is very interested to know whether it's really settled. And so it's a little weird to say, oh, it's settled law, but we don't know if it'll stay settled, in 2 years. Just being realistic about it, descriptively, surely it's not settled.
Mm-hmm. Okay. Now, yes.
So I just was wondering if you'd been brought out here to advise the general counsel of the university. You have in Baude only one justice thinks that there's not, quotas are unconstitutional, but diversity is, which is a very ambiguous position, I would say. And then you have that reaffirmed in the Michigan cases by one justice, flipping and flopping. And now you have one justice in the Fisher case. But then you have all these universities. So you have a settled practice out there, maybe, because lots of universities are out there. So have you now found the argument that will persuade Justice Roberts?
No. Okay, so affirmative action and liquidation. It's true, there's a lot of, in the Supreme Court decisions, there's a lot of ambiguity. I think the first problem is a lot of judges who are skeptical would say the Constitution is not ambiguous, that it's colorblind, that it, tolerates no discrimination, et cetera. Whether that's right, we can go into the history, and it's complicated, but the first issue is, I think, whether there's actually a constitutional ambiguity is one of the ground zero questions. Another is then, while the courts have sort of spoken repeatedly, they haven't exactly struck a clear path. Even as each decision seems to kind of veer back and forth from one set of rules to another. So it's not as if even the courts have kind of settled on one practice or rule. And when I look more broadly at the other branches, like the Department of Justice, definitely doesn't seem to have settled on it. It's on both sides of this issue, depending on who's in control of the administration of the Department of Justice. And it changed, even in the course of the Harvard litigation. So that's, I think, the hallmark of not liquidated, that we see, as the party changes, the side changes, there's not any kind of bipartisan or other buy-in to one side or the other. This is also in the category of things we're still obviously fighting about.
We've given you a workout and exhausted ourselves, I think, before you. All right, well, thanks very much.
I can win by attrition.